Peace. Welcome back to the You and I verse Soul Temple for the Sun, Planet, Moon, and Stars. To be your Lord of Hosts, Lord Messiah. And this right here, we're going into trial. So let's get it. It's the next section. Trial. About to get it. Let's go.
Trial. After many weeks or months of preparation, the prosecutor is ready for the most important part of his job, the trial. The trial is a structured process where the facts of a case are presented to a jury, and they decide if the defendant is guilty or not guilty of the charge offered. During trial, the prosecutor uses witnesses and evidence to prove to the jury that the defendant committed the crimes. The defendant, represented by an attorney, also tells his side of the story using witnesses and evidence. In a trial, the judge, the impartial person in charge of the trial, decides what evidence can be shown to the jury. A judge is similar to a referee in a game. They are not there to play for one side or the other, but to make sure the entire process is played fairly. Jury selection.
Well,
at trial,
I gotta beg to differ on that, because like I said, when the judge automatically gives favor to the prosecution to just verbally file motions on the spot in the court. Meanwhile, when you file a motion, you gotta write it up, file it, go through all of this, serve the other person, do all of that. But they could just serve motions right there, open in the court. Oh, well, that's why you're at a serious disadvantage, because you don't have an attorney. Bullshit. I just want us to go through this long ass process and exhaust us when they could just get their favor and do what they do, because they all working together, man. It's a conflict of interest. Judge employed by the Bar Association, and isn't the prosecuting attorney and everybody else in that courtroom employed by the Bar Association? Well, more so the lawyers and the attorneys and the judge. So isn't that a conflict of interest off the bat? But anyway, that's another topic. Let's stick to the strip.
When selecting the jury, the prosecutor and defense attorney may not discriminate against any group of people. For example, the judge will not allow them to select only men or only women. A jury should represent all types of people, races, and cultures. Both lawyers are allowed to ask questions about their potential biases and may excuse jurors from service. Each side is allowed to excuse certain potential jurors without providing a reason by using a limited number of peremptory challenges. Opening statements. Opening statements allow the prosecutor and the defense attorney to briefly tell their account of the events. These statements usually are short like an outline and do not involve witnesses or evidence. The prosecutor...
So what about if you in a state where the majority of the population is Caucasians, and they say a jury of your peers is all white jury? Is that fair? You know what I'm saying? Because there's many cases where that happened. They had an all white jury, and a black person is the defendant. You know, a melanated person is a defendant. So is that fair? But anyway.
Prosecutor makes an opening statement first because the government has the burden of proving that the defendant committed the crime. Presentment of cases. Witness examination. Following opening statements, the prosecutor begins direct examination of his first witness. This is the prosecutor's initial step in attempting to prove the case, and it can last from a few minutes to several days. During direct examination, the prosecutor can introduce evidence such as a weapon or something from the crime scene. Following the prosecutor's examination of a witness, the defense attorney has an opportunity to cross-examine or ask questions to the same witness. The purpose of cross-examination is to create doubt as to the credibility of the witness. After the defense attorney cross-examines the witness, the prosecutor asks the witness final questions to clarify any confusing testimony for the jury. This is called redirect examination. Once the process of direct examination, cross-examination, and redirect of all the witnesses is complete, the prosecutor rests his case. After the prosecutor rests, no more witnesses can be called to the stand or evidence introduced by the government. After the government rests, the defense has the opportunity to present witnesses and evidence to the jury. The defense also has the option of not having the defendant testify. There is no burden upon the defendant to prove that they are innocent. It is the government's responsibility to prove the defendant committed the crime as detailed in the indictment. The fact that a defendant did not testify may not be considered by the jury as proof that the defendant committed the crime. The defense may also waive his case. If the defense does not put on any evidence, the jury cannot assume that the defendant is guilty simply because they did not put on a defense. The decision to put on a defense is solely up to the defendant and the defense attorney. However, the defense will usually present its own version of the case.
Right, because usually they don't want the defendant to take the stand because he may slip up and say something that incriminates him. So they'll rather, them they'll just speak for you more so. And also too, it says the defense may waive his case if the defense does not put on any evidence. The jury cannot assume that the defendant is guilty simply because he does not put on a defense. So in other words, just because the defendant doesn't speak, they can't just say, oh, he's guilty, why isn't he saying anything? Because he has a right to remain silent so he doesn't incriminate himself, and it also has the right to legal representation. This is why they say get a lawyer, get an attorney. So, you don't incriminate yourself, you know what I mean? However, the defense would usually present its own version of the case. So, your defense attorney, or the attorney for the defendant will present the case. You know what I mean? It's not really wise that the person speaks themselves. That's why you see, like in the court cases or in the movies, whatever, when they having a court case, they be like, well, we don't really want you to take the stand unless it's really necessary. You know what I'm saying? Like they do that at last resort. You know what I'm saying?
Case. Objections during direct or cross-examination. Either attorney can make an objection to a question or a piece of evidence to the judge. For example, a prosecutor or defense attorney may object to the wide range of the direct examination because it is beyond the knowledge of the witness. The attorney may be arguing with the witness rather than asking questions, or the witness may be talking about things irrelevant to the case. Common objections include hearsay, statement by a witness who did not see or hear the incident in question, but learned about it through second-hand information such as another statement, a newspaper, or a document.
Right.
Relevance, testimony, and evidence.
Right. Once again, like I said, a police report, they are not first-hand witnesses to anything. They learn about it through second-hand information such as other statements, another statement, a newspaper, or a document. So like if a person calls the police and writes it and files a statement, they're getting second-hand information from another person's statement. You know what I'm saying? So relevance, testimony, and evidence presented at a trial must be relevant to the case. So if a witness is getting up there saying stuff, that whatever they're saying, it has to be relevant to the case. Otherwise, they can be stricken from the record.
Evidence presented at trial must be relevant to the case. The judge decides the outcome of an objection, sometimes after allowing attorneys on both sides to comment before making a ruling. The judge either sustains the objection so that the action stops, or they overrule the objection and allows the action to continue.
Right. So, for example, they may say, objection, prosecution is leading the witness. So, like, in their form of questioning, if they're saying, well, you were at this place at this time, weren't you? You did do this. Like they can't lead the person into admitting something or saying they did something, or, you know what I'm saying? That's like leading the witness. They can only ask questions in a way that's not incriminating the witness or badgering the witness, you know what I'm saying, and what have you.
Closing arguments after the defense's direct testimony and cross-examination by the prosecutor of all the witnesses, the defense rests, and the prosecutor and defense attorney prepare for closing arguments. Closing arguments are the final opportunity for the prosecutor and the defense attorney to talk to the jury. These arguments allow both attorneys to summarize the testimony and evidence, and ask the jury to return a verdict of guilty or not guilty. Jury instructions. Following the closing arguments, the judge charges the jury, or informs them of the appropriate law and of what they must do to reach a verdict. Jury deliberations and announcement of the verdict. After being charged, the jury goes into deliberation, the process of deciding whether a defendant is guilty or not guilty. During this process, no one associated with the trial can contact the jury without the judges and lawyers. If the jury has a question on the law, they must write a note to the judge, which the judge will read in court with all parties present. In federal criminal trials, the jury must reach a unanimous decision in order to convict the defendant.
Right.
After they reach an agreement on a verdict, they notify the judge, the lawyers, and the defendant in open court. Everyone is present in court for the reading of the verdict. The United States Marshals Service is present during trial to protect the judge and prosecutors from potential harm. If the defendant is found not guilty, they are usually free to go home.
And if not, they will have them remain in the custody of the U.S. Marshals until sentencing. But they say the U.S. Marshals are on deck to prevent the judge and prosecution from potential harm. Exactly, because after you just sentence somebody or just found somebody guilty, they might wild out. You know what I'm saying? So they try to make sure the judge is all right. They try to make sure the prosecutor is all right. You know what I'm saying? They try to make sure that the defendant don't wild out after being found guilty on some bullshit. But anyway, I'm gonna end that one, y'all. I'm gonna see y'all on the next one. This has been Trial, and what we got left? We got post-trial motions, sentencing, and appeal. Alright, so I'll see y'all in the next one for that, y'all.